Okay, we'll begin. Good morning. Thank you for coming, even on icy streets. I appreciate it. I am Jennifer Jewell Thomas, and I have served on the boards of the two organizations featured today, Citizens for Election Integrity Minnesota, or CEI, and Minnesota Unitarian Universalist Social Justice Alliance, MUUSJA, pronounced Moose Jaw. These organizations are jointly releasing a report today entitled Facts About Ineligible Voting and Voter Fraud in Minnesota. It's based on data from the 2008 election collected earlier this year from Minnesota's county attorneys. If you can't stay for the full press conference, let me give you the executive summary now. Voter fraud is not a problem in Minnesota, and a photo identification requirement for voters is completely unnecessary. In fact, some of our speakers today will provide additional information on why a photo ID requirement would be very bad for Minnesota voters. We'll also discuss recommendations related to felon voting. To understand the need for this groundbreaking report, it's important to know that investigations of ineligible voting and prosecutions of voter fraud are handled at the county level. So there's a lack of comprehensive statewide data available in Minnesota. However, we see frequent allegations of voter fraud in the press, fueling interest in the legislature to require all registered voters to present a state-issued photo ID when voting in person. Like all Minnesotans, we take allegations of voter fraud seriously, so we set out to learn the facts to inform this debate. Voter fraud is a felony, so county attorneys are responsible for the investigation of ineligible voting and the conviction of those who commit voter fraud. We mailed a survey on this subject to all 87 county attorneys in Minnesota, and the authors followed up with those who did not respond. Ultimately, we had responses from 71 counties representing all the metro area and over 93% of the votes cast in 2008. Our report includes the investigations and prosecutions reported as of the survey, which was about 18 months after the election. Today, several speakers will highlight the key findings and recommendations and comment on the report. Our first speaker, Carol Johnson, is a head election judge in Minneapolis and is a member of the organizing committee of CEI and is also a member of Moose Jaw. Carol is co-author of the report and will provide an overview of the safeguards in place to ensure the integrity of voters in Minnesota elections.
Good morning. We don't believe enough people are aware of the number and the depth of the safeguards that are in place to ensure that eligible voters can vote, ineligible voters are prevented from voting, and fraudulent voters are caught and prosecuted. This report identifies 11 safeguards that deal specifically with the voter that are in place in Minnesota to ensure the integrity of the vote. Safeguard number 1, we have a system of registration. Unlike North Dakota, Minnesota voters are required to document who they are and where they live. Safeguard number 2, the registration oath. Both election day registrations and the voter whose name appears in the poll book at the precinct must sign the same oath, verifying that they are eligible citizens and the information provided is accurate. Giving false information is a felony, publishable or punishable by not more than 5 years imprisonment or a fine of not more than $10,000 or both. Safeguard number 3 is verification of the newly registered voters. Those who register in advance of Election Day will have their information verified by the Department of Public Safety, their name, address, date of birth, and if available, the last 4 digits of their Social Security number and/or the Minnesota driver's license will be required. The DPS determines if there is a match. If there is not, the county auditor reviews the record. Then they will, if they cannot verify the newly registered voter who they say they are, the voter's name will be marked by the word challenge in the precinct poll book. There are 6 types of challenges: felony, guardianship, name and address, different address, and a different address from the application that they had for an absentee ballot, and then the postal return. If the voter appears in the precinct to vote, the head judge or roster judge will ask specific questions and require them to swear to the truthfulness of their statement. There are 3 possible outcomes: refuse the oath, not eligible to vote, or they are eligible to vote and then they go ahead and do their voting. Safeguard number 4 is the statewide voter database. Registered voters' names and information are housed in one place, rather than each county. County auditors can check to determine if newly registered voters are already registered elsewhere in the state. The most recent registration will remain, and the older registration will be purged. Safeguard number 6, and this is something we think will change a lot, make things much more efficient, is the newly improved Minnesota Department of Corrections data dissemination. County-level election administrators review the data provided by corrections regarding new felons and felons who have completed their sentences. The election administrators use the data to update the voting lists, to remove the felons' names, thereby they cannot vote, or possibly mark the poll book challenged by their name. Felons who have completed their sentence are allowed to register and vote. Until 2010, felon status and to determine the appropriate action in the poll book. Safeguard number 10 is transparency after the election day, where selected information from the voter lists is made public. Indeed, we learned that many of these investigations from the 2008 election were initiated by one or more outside organization based on these public lists. Safeguard number 9 is the post-election review of voters. After the election, state and county officials conduct an internal review of all voters, including election day registrants, using the statewide voter database. After analyzing the data, if there are allegations or suspicions of voter fraud, either the Office of Secretary of State or the county election administrators provide the information to the county attorney. Cases of possible ineligible voting are referred to the corresponding county for investigation and prosecution. Safeguard 11 is the actual investigation by not qualified. The final safeguard are the investigations by the county, which provides the main source of the data for this report today. Thank you.
Thank you, Carol. Our next speaker is Kathy Bonifield. She's Associate Director for CEI and co-author of this report. Kathy will review the survey results.
Often people talk about possible fraud, but usually they do not cite specific examples, or they only cite one example, and very few cite convictions. Because it is a felony for someone to intentionally lie about voting qualifications, county attorneys are responsible for the investigation of possible cases of fraud and the convictions of people who have committed fraud. For that reason, it made sense to go directly to county attorneys to learn more about this specific issue. Our survey asked county attorneys to inform us about their investigations and convictions into this matter. We ask that they only report on investigations following the 2008 elections. So this does not include the 2010 elections. Of Minnesota's 87 counties, only 16 did not respond to this request. Those who did respond represented over 90% of the 2008 voters. For this reason, we believe the survey has a really good response. I would like to mention that people responded to our survey between April and June of this year, and there are still ongoing investigations. The survey was basically separated into 3 parts. The first part asked about the total number and types of investigations. The second part asked about the outcome of those investigations. And the final section asked county attorneys if they felt fraud was a problem in their county and in the state. There were over 1,500 investigations throughout the state. A small portion of the investigations included possible non-citizens voting, double voting, which means someone voted twice, voting at the incorrect precinct, and voter impersonation. There was not one single conviction for any of these reasons. In fact, Anoka County reported they had investigated cases of double voting, again, that's someone voting twice, but they determined voters shared the same name and the same date of birth. So they were different people, and double voting had not occurred. We are surprised to learn that over 77% of the investigations were for one reason, and that was possible felons voting. Before I go into the number of convictions, I would like to highlight some of the information that was provided to us. Of all the completed investigations, 66% were not chargeable, so the cases were dropped. While we did not ask for it, 2 counties provided us with additional details regarding why the cases were not chargeable. I'd like to provide you with 2 of the most common reasons those 2 counties provided us. Just over half of the not chargeable cases in Dakota County and just over 80% of the not chargeable cases in Anoka County were dropped because the individual did not know they broke the law. In Dakota County, 35% of the not chargeable cases and 5% of the not chargeable cases in Anoka County were because the investigation determined the voter had been convicted of a gross misdemeanor, or the voter had been discharged from a felony probation at the time of voting. In other words, they were investigated as possible felons voting, but in fact they had every right to vote. Since we didn't ask counties to provide us with specific details regarding why the cases were not chargeable, I'm not sure if Anoka County's 5% is the norm, or if Dakota County's 35% is the norm. But it does tell us that there are people who are investigated as possible felons voting when, in fact, they had every right to vote. Now I'd like to talk about convictions. The only type of conviction was due to felons. In total, 26 people were convicted because they had not completed their sentence and voted, while an additional 12 convictions were because felons registered to vote, but they did not vote. To put this into context of the percent of 2008 voters who were convicted of fraud, we should just look at the 26 people who voted and were convicted. In 2008, a little over 2.9 million people voted in Minnesota. So of the 2.9 million people who voted, 9/10,000ths of 1% were convicted of fraud. As I mentioned earlier, in addition to asking about the total number and types of investigations and convictions, we asked county attorneys their opinion regarding fraud in Minnesota. About half of the county attorneys responded to this question, meaning half of them didn't respond. And many wrote a simple no to the question, do you think voter fraud is a problem in your county and in the state? 2 counties, Mille Lacs and Polk, did respond that they believed it was a problem. One of the 2 attorneys specifically mentioned felons voting, while the other one just mentioned a general concern about ineligible voting. Many counties said that they did not believe fraud to be a problem in the state, but they did express a concern regarding felon voting. For example, the Dakota County attorney wrote, and this is a fairly long quote, but I think it's really important, the majority of the cases that have been referred to our office involved convicted felons voting. During the investigation of these cases, many suspects indicated they didn't know they couldn't vote. Several suspects stated they were told by an election judge that they could vote because their name was on the roster or their probation officer never told them they couldn't vote. In check-in with Dakota County Community Corrections, it was discovered that the discussion of voting rights was not routinely discussed with probationers. It appears as if these suspects were not trying to commit any sort of fraud in voting. They were voting because they thought they could. None of the suspects tried to hide the fact that they had voted and that they were convicted of felonies. They were forthright with law enforcement, probably because they didn't know they did anything wrong. All these individuals were notified in writing that they were ineligible to vote. They were notified that they could not vote in future elections until their civil rights were restored, and they were advised that if they did so, they could be prosecuted. The county attorney continued writing, "Voting fraud is not a significant problem in this county or in our state. If more time or effort were spent on this issue, it seems that education may be the best place to start. This would include educating probation officers, convicted felons, and election judges." And that's the end of his quote. So in addition to expressing his concern about felons voting, his statement also highlights an important issue that's discussed in the report. In order to be convicted of a fraud, you have to intentionally break the law. So if someone didn't know they couldn't vote, they did not break the law. As I mentioned earlier, the most common reason that cases were found not to be chargeable in Dakota and Anoka counties was because people did not know they broke the law. And that's just a brief overview of our report. I hope you read it.
Thanks, Kathy. Now we will hear from John Kingery, Executive Director of Minnesota County Attorneys Association.
Good morning. My name is John Kingery, Executive Director of the Minnesota County Attorneys Association. I do want to emphasize that county attorneys do take voter fraud very seriously. Under Minnesota statutes, when notified by affidavit, we must promptly investigate, and if there's probable cause, we must charge that individual. There is no discretion for county attorneys in this particular area. Failure to do so results in the loss of the county attorney's office. Earlier this year, county attorney offices were sent information by an organization alleging widespread voter fraud by felons in the 2008 election. This drumbeat continued with a letter from a political party requesting a formal investigation based on that information from that organization. This issue continued later this summer when all counties were served by a news organization directing counties not to destroy the absentee ballots from the 2008 elections. Based on the anecdotal evidence so far, the list generated by the organization that I mentioned earlier wildly overstated the number of felons that voted. As was said earlier, many actually were legal voters. They were allowed to vote under Minnesota statute. This matter has taken up considerable prosecutor and law enforcement involvement and also resources at a time of dwindling budgets. It also impacts the strapped budgets of our public defenders and the courts as well. Our priority must remain public safety. The diversion of resources to investigate frivolous voter fraud causes nothing to protect public safety. Accordingly, our President, Charles Glassrud, the Stevens County Attorney, announced the formation of a task force last summer to correct these problems, to try to identify them at the front end rather than the back end like we're having to do under the current system. The task force is charged with reviewing Minnesota statutes, case law, and recent proposed legislation on voter fraud that was also vetoed, and make recommendations on best practices and policy considerations to our Board of Directors at their 2011 meeting this coming January. Thank you.
This brings us to our first recommendation of the report. Do not institute a photo identification requirement to vote in Minnesota. A government-issued photo ID would not improve the integrity of our elections because it does not address a documented problem. Since no government-issued identification shows a person's criminal status, a photo ID would not prevent the only voter fraud reported. A Minnesota House report authored by Representative Tom Emmer reports the cost to implement a photo ID would be from about $500,000 to $2 million, with ongoing impact at the state and local level. Our report shows that this would be an unnecessary use of taxpayer money. Furthermore, photo ID would unfairly establish different standards for absentee and in-person voting. More importantly, nonpartisan reports have documented that a photo ID requirement would cause harm by selectively suppressing the right to vote for many voters. We'll hear next from Laura Wang, Public Policy Coordinator, League of Women Voters, Minnesota.
Good morning. My name is Laura Frederick Wang, and I am the Public Policy Coordinator at the League of Women Voters Minnesota. We would like to thank the staff and volunteers at Citizens for Election Integrity for this report. Voter fraud has received a great deal of attention recently, but unfortunately the debate has focused more on rumors and conjecture than on facts and data. LWV Minnesota hopes that the report's findings will address that gap. According to the findings of the report, there is broad agreement among the county attorneys in Minnesota about our election system and the possibility of voter fraud. Nearly all of the county attorneys responding stated that the vast majority of wrongfully cast ballots are by felons who have not yet had their civil rights restored. Voter impersonation, double voting, and other fraud schemes that have dominated the discussion around voter fraud and the impetus for pushing measures such as a photo ID requirement were not identified by the respondents as a problem in Minnesota. We are all concerned that every vote that is counted was legitimately cast. For that reason, it is critical that lawmakers pass legislation in the upcoming session to improve the process for notifying felons of when they have lost their civil rights and when they are restored. Improving this system will reduce the number of wrongfully cast ballots while not limiting access to the ballot by eligible voters like a photo ID requirement would. Jenny referenced studies by nonpartisan organizations about the impact of photo ID requirements. That includes the Brennan Center for Justice out of New York City that identified that approximately 18% of seniors over the age of 65 do not have a photo ID. I believe it's roughly 12 to 15% of citizens with disabilities also do not have photo ID that would make them eligible for voting. So those are just a few of the examples. Lawmakers will be forced to contend with a historic budget deficit in the upcoming legislative session. It is always important that state funds be used wisely, and that is even more true now. This report from Citizens for Election Integrity provides lawmakers with guidance as to how to best use those resources while we work to keep Minnesota's election system among the best in the nation. Thank you.
Our next recommendations relate to the current election law that we think should be changed. We recommend changes that would reinstate the right to vote for all non-incarcerated felons. Until this is passed, we also recommend legislation that require informing convicted felons when they can and cannot vote. A law requiring this notification passed the legislature in 2009 by a wide margin, but was vetoed by the governor. We believe it should be reintroduced and passed into law. Our next speaker, Sarah Walker, is Chief Operating Officer of 180 Degrees and leader of the Second Chance Coalition. Sarah will comment on the impact of allowing non-incarcerated felons the right to vote.
Thank you. So I'm here as a representative of the Minnesota Second Chance Coalition. The Minnesota Second Chance Coalition is a nonpartisan coalition that represents over 53 organizations throughout the state. And we advocate for fair and responsible laws, policies, and practices in our justice system that allow for individuals who have made mistakes to become contributing members to our society. Our coalition represents a diversity of organizations ranging from mental health advocates to faith-based organizations. And we do understand and believe in accountability, and we also do hold public safety dear. But we also acknowledge that accountability must coincide with opportunity. And during the 2011 legislative session, the Minnesota Second Chance Coalition will bring forward the Minnesota Voting Restoration Act. This legislation would allow the right to vote for individuals who are on probation and parole in Minnesota. Over 60,000 Minnesotans would be reenfranchised by allowing parolees and probationers to vote. Since 1974, the number of individuals disenfranchised as a result of a felony conviction has increased 500%. Minnesota has the fourth highest rate in the nation of individuals on probation. And in Minnesota today, 1 in 26 Minnesotans is on some form of correctional supervision. This is not due to an increase in crime rate. We have simply just become more punitive. And the result is that the majority of individuals currently disenfranchised by the law have never spent time in prison. And 87% of the state's disenfranchised live in the community. They hold jobs, they pay taxes, and they raise their families. They are our neighbors, and they are often our friends. In 2007, the number of individuals disenfranchised as a result of a felony conviction was nearly 2% of the state's total population, voting age population. And while our current policies and practices disproportionately impact communities of color, the reality is that disenfranchisement law impact all of Minnesotans. Individuals who identify as Caucasian comprise almost 70% of the convicted felon population, and the majority actually live outside of the Twin Cities area. So this is not a partisan issue. Studies have actually shown that the disenfranchised population are not likely to be loyal to any one party. The population disenfranchised is as diverse as our state is, both demographically and politically. The Minnesota Voting Restoration Act would eliminate both the cost of time-consuming investigations and the confusion about eligibility. In addition, there may actually be a public safety benefit. Voting can be a powerful and concrete, symbolic way to contribute to the community and a means for individuals who have made mistakes to take a positive and active role in their lives. Research has actually found that probationers and parolees who exercise their right to vote are less likely to commit future offenses. And in recent years, both Connecticut and Rhode Island have expanded the right to vote for individuals with felony convictions living in the community. And currently, 20 other states allow individuals with felony convictions to vote. Again, this is not a partisan issue. Re-enfranchising thousands of people will not change elections. It will change people. It will change the people who vote. It will send a message to people struggling to find work in the Iron Range, people raising families in the Twin Cities, and people going to their kids' hockey games in Moorhead and Wilmer. It will send a message that we want you in the community, we want to hear your voice, we want you involved. It will send a message of inclusion. I think it's important to remember that all research demonstrates that political participation is something that's learned. It's passed down in families and communities. So continuing to disenfranchise tens of thousands of Minnesotans will impact not just this generation, but future generations. And so in 2011, we will be asking for support for the Minnesota Voting Restoration Act.
This brings us to our final recommendation. We urge the legislature to change the deceptive practices in elections law from a gross misdemeanor to a felony with the requirement to serve time. People who intentionally and illegally deny others the right to vote should lose their own right to vote. In conclusion, our report shows that a year and a half after the most closely scrutinized election in Minnesota history, county attorneys reported only 26 convictions statewide for voter fraud. Not one of these illegal voters could have been prevented by a requirement to present a photo ID. The facts documented in this report show that a photo identification requirement to vote is completely unnecessary to prevent voter fraud in Minnesota, and indeed could not possibly justify the well-documented harm and expense. We'll now take a few questions.
Could you reiterate the protections for same-day registration?
Do you want to go through that, Carol?
Sure. Same-day registration Same-day registration requires that the individual come there with a way to determine that they are who they are and they live where they live. And so the photo ID that is used is the driver's license. That's a simple one. If they don't have a current driver's license or Minnesota ID or tribal identification, then they can use an outdated Minnesota driver's license with a utility bill. And they can have that utility bill displayed in paper or on a computer. And then the third way is through vouching. Someone who lives in the precinct, is a voter in the precinct, can vouch for a new voter who lives in that precinct. They must have personal knowledge of that individual, and they fill out a form. The person that's vouching swears that they are who they are, and the individual also has to take the same oath. And remember, lying on your registration puts you in jeopardy of 5 years in prison or $10,000 fine. And as you can see, our county attorney, the system does the investigation. The checks are done on the individuals, and before the election and after the election, we check on newly registered voters.
Questions on vouching.
Sure.
How many people can you vouch for, and then what are the penalties the same if you illegally vouch for somebody that they would be as casting an illegal vote?
Yes, I think an individual can vouch for up to 15 people. My experience in 16 years as an election judge in Minneapolis, one person. They usually vouch for one person. Group homes come in with a list, and we don't have many group homes. We don't have any in ours, but they have a list of their residents, and they can vouch for them, for their residents. I am not familiar with the issue that's before the county or the election officials right now is at the universities. So, because I don't know if Kathy wants to speak to that. Okay, but a person can vouch for up to 15 people, but that's not the experience I've had.
Penalty
I'm not sure, but I would think that the voucher has the same penalty of 5 years imprisonment or $10,000 fine.
And just to reinforce, the investigation, the report that we conducted includes all voters. So same-day registration, vouched, all of them are included in this. So because they all go through that same process of being reviewed post-election.
You've said, and I don't know who wants to answer this, maybe John,
Yeah.
that allegations of widespread voter fraud are wildly overstated. Many hours spent on this. How much money is spent on these kinds of investigations that you say do nothing to protect public safety?
That's right. I know in the Twin Cities, one of our counties, they've hired 2 part-time investigators to review those lists. I know another large metro county devoted numerous hours to investigating, not only in terms of reviewing the list, turning them over to law enforcement, who then has to talk to probation officers and other folks within the correction system, and then ultimately the person that voted, if you can find them. And part of what our task force is going to do is to try to come up with some measurement in terms of what this costs. But again, our number one priority is public safety, and we don't see spending large amounts of time and resources on these issues as reinforcing public safety.
Do you believe that these investigations are politically motivated?
I believe these investigations are brought forward by individuals that believe that there is illegal voting done, and I'll leave it up to those organizations to define why they're bringing these cases to us.
And you can state flatly, there isn't. There's a few cases here and there.
There's a few cases here and there. The list that was provided to us last July to the county attorney offices were just, they weren't by county, they were by city. Again, when you reviewed them, a number of individuals had already gone off probation. Maybe by the time they voted, they were no longer felons. It just was a lot of work on a very, very poor list that was given to our county attorneys. And again, based on the anecdotal stuff that I've heard, I think you've seen as well, very, very few have actually been prosecuted. I'm only aware since 2008, I'm assuming you're aware of it too, of one case that was prosecuted up in Polk County that resulted in a 2-day trial in which the charges were, it was dismissed. And that individual voted for Mr. McCain and Mr. Coleman.
Mr. Kingery, would you go so far as to say that the Minnesota Majority List has actually interfered with public safety because it's kept your resources from focusing elsewhere?
I would say that it's diverted resources away from the job that we want to do. We want to take care of the bad guys that are in our communities, and I think it goes without question that it's diverted resources. All aspects of the criminal justice system are receiving fewer dollars, whether it's the courts, the public defenders, or county attorney offices. And we're trying to do the best we can do with the resources that we have available.
Mr. Kingery, I wonder if you might comment on the effect to the electorate, what you see, what you hear amongst your colleagues about how these sorts of cases might affect confidence in the system and whether or not that confidence might be eroding, and that helps lend itself to more claims of fraud.
You know, I think the report pretty much details what the county attorneys think, that they don't believe there is widespread voter fraud. And I believe at the end of the day, when the dust settles, you'll see that very, very few cases were actually prosecuted. Again, we have to prosecute these cases if there is probable cause.
Does the County Attorneys Association support the recommendation to let non-incarcerated felons go?
Thank you for asking that question. We are going to review all the recommendations in this report, as well as the statutes that were vetoed the last 2 years, and come up with some recommendations, but we will seriously consider this. The last time we looked at this particular issue was in 2005.
So just to be clear, you are not here supporting the recommendations of this report?
No, we are saying that we are going to review them. We have formed a task force and to come up with recommendations to our board of directors at their January 2011 meeting.
Where did you come from in 2005 when you looked at?
We took no position. We didn't oppose it, but we took no position at that time.
Could any of you address or explain the bounce back photograph or postcards which are enumerated in the tens of thousands by people who are questioning this election?
I think I can answer that, but I'm not an expert in all the bounce backs. One thing is that when you register to vote, you can register same day and the postcards are sent, but you might actually move. So I know that if you do move, it would bounce back, so that does work. But in other cases, I'm not certain of why they would be bouncing back. But some people do move between times.
That is a challenge on the poll book. It's postal return, and in our precinct this election we had one, and it was due to a clerical error because the address of the individual was deviation from what it actually was. So she just registered again. The cards are sent out by the official elections offices, and oftentimes in the past, cards have been sent out by political parties, and those are not legal in Minnesota. They are not to establish residency. A lot of times people receive these cards and they don't want to respond to them because they know where they're coming from, and so then they are taken as evidence by the particular party that wants to cause the bounce back to rise up. I think that's grossly overestimated.
Are there any more questions? Thank you very much for coming today.